Rita Pasarell of the Sexual Harassment Working Group. This is the group that really catapulted the issue into the public eye and really helped move it forward. Rita, let's hear from you. And then I think Angie will go to you right after that.
Sure. Thank you so much. Thanks to our host, Time's Up, all the workers and advocates on the call, all my co-speakers. I'm going to start by telling a little bit about my experience being sexually harassed at work and then plug it in to some of the changes that we've seen in the law this past year. So I worked for the New York State Assembly in 2011. I worked for Assemblymember Vito Lopez, and he was a sexual harasser almost every day. And I and my coworker, Leah A. Bear, reported him to the Assembly for sexual harassment. About 6 months later, we entered into a settlement agreement, and that contained a non-disclosure clause. About a month after we signed, we had first found out that the Assembly never investigated our complaints of harassment, and also that new employees had been hired by Vito and that he had harassed them and that they complained, and they wound up suing. So around that same time, I applied for unemployment because a part of the settlement agreement was that I would resign from the job, and I did. I was denied unemployment because I wasn't able to talk about what happened at work without violating the non-disclosure agreement. So fast forward to last year, a bunch of these changes that we saw in the laws were informed by these two sexual harassment hearings that Senator Biaggi mentioned, and that's because we need to hear from the people who laws affect. So when sexual harassment and discrimination laws are being crafted, of course we want to hear from workers to know how prior laws have harmed them. So we can go to the next slide. And I'll be brief on this one. It's just some background. I want to highlight when we're talking about these laws, it's important to say that sexual harassment is a form of sex-based discrimination under federal and state law. Hopefully soon we'll be like New York City and call it gender-based, but for now it's sex-based discrimination. And I like to highlight that because it's just as bad as any other form of discrimination. And there are other types of discrimination, as Dana had mentioned, aside from sexual harassment, and other forms of harassment, rather, aside from sexual harassment. And we can move to the next slide. And I'll get into the specifics of the laws that I'm going to talk about. One of the key points is that now victims and workers are going to have a longer time to report to the New York State Division of Human Rights, as you've already heard. We're going to have 3 years now to file a sexual harassment complaint, up from 1 year. And this is so key because of how trauma works and also just the realistic way that power works in a workplace. There are so many reasons why people don't report at work, and many of them are unfortunately rational because retaliation is really common. And also something that we hear really frequently when people reach out to us now in the Sexual Harassment Working Group is they say, I didn't report at the time, but now I've heard the harasser is doing it again, and now I want to report. So this change helps that happen. It helps the continuity of a repeat harasser, which many harassers are. And I'm going to move to the next piece, the non-disclosure protections. Something that is an unfortunate tension in this area is that when a worker is harassed, they are entitled to the compensation for the harm they've received, but also new workers need to be protected at the same time. So when a worker winds up with a settlement agreement and there's a confidentiality or non-disclosure clause in there, often that can come at the cost of new workers finding out the information that they should have had to protect themselves. And the change to the law helps to fix that, because now non-disclosure agreements, they can't prohibit an employee from participating in an agency investigation. So new workers could be privy to this information, or the agency can put a stop to harassment, hopefully before new victims come about. Also really important to me is that the non-disclosure agreements can't prohibit a worker from disclosing facts necessary to receive unemployment or other public benefits, like what happened to me and my coworker. And the last change I'm going to touch on is that there used to be a defense, and it partially exists, where a employer can point the finger in blame at a worker who didn't complain of harassment. So now that is no longer able to take place. It's no longer determinative if a worker doesn't report harassment to their employer. And this is a much more fair way for the law to be, because if an employer doesn't take harassment complaints seriously, they'll get that reputation among workers, and workers are not going to tell them about the harassment. So it's not right for an employer to create this bad environment where they're not taking complaints seriously and then yet blame the worker for then not coming to them. So that is really all I have to say about these laws here that we have. And I do just want to underscore how important it was to have those sexual harassment hearings where we hear the testimonies from the workers from experiences like mine and other people who have had these bad things happen to them at work. But we now have built that into some good benefits where we hopefully can stop that from happening to more people. And I want to again thank the Time's Up and